नमस्कार, मैं एडवोकेट अभिषेक रंजन सिंह। केस नंबर 8 एंड ये बहुत लेटेस्ट केस है, तो इसके बारे में जानना है। इसमें जो चीज़ें हम जानेंगे वो होगी डिसेबिलिटी पेंशन की, ऑब्वियसली ब्रॉड बैंडिंग की, एरियर्स का, लिमिटेशन एंड आर्टिकल 300 ए ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया. Now, Sergeant Girish Kumar versus Union of India and others, it's like a capstone for the areas of disability pension, जो कि बहुत लेटेस्ट जजमेंट है. अब इसमें हुआ क्या, once the entitlement to a disability pension is judicially affirmed, its areas cannot be curtailed to 3 years by invoking a limitation, delays, or lashes. Disability pension, the court reiterated, is not a bounty or a or bounty, but a vested recurring right in the nature of property by Article 300A. Now, एरियर्स के बारे में हमने पढ़ा रामावतार के केस में, जो बहुत क्लियर हो गया था कि दे कैन नॉट बी एनी लिमिटेशन. बट व्हाट इज द इशू is that different AFTs were pronouncing different judgments. It was a it was not uh, it was not open to discussion that you can do anything. It is a well settled law. But what happened is that because there was confusion, कोई AFT 3 years limitation लगा रहा था, कोई 5 years limitation लगा रहा था. Now that created a confusion. A bunch of petition was filed in the Supreme Court of India, and now the actual thing in Girish Kumar, Sergeant Girish Kumar versus Union of India. Now it has set the benchmark for the areas. So Sergeant Girish Kumar was enrolled in 88. He completed his tenure in 2008, was assessed at 20% of disability for life, and was granted the disability pension accordingly. Now, what happened in 2014? This Ramavatar judgment came. When the Ramavatar judgment came, according to which the 20% should be considered at 50%. But and when this Girish Kumar went to the court, he was not granted relief. जो जजमेंट 2014 में आया, which has set the precedent that the broadbanding will be done 20% का 50%, 50% का 75%, and 70% 75% का 100%. But in that case, it was not given. Now, this was the question in law which Supreme Court has to solve. What Union of India said, that because there is a limitation, we cannot give it. Because as in the monetary matters, there is a limitation of 3 years at the date of filing. And that is how they were behaving. That is how they were granting the disability pension. And this created a confusion. Now, the arguments by the appellants, the Union of India grievances was confined to the direction to pay arrears of disability pension beyond 3 years. Now, Union of India said we can give disability pension 3 years from the date of filing the case. The second, claims for arrears of disability pension was governed by the Limitation Act 1963, Section 22 of the AFT Act 2007, and even cases of continuing wrong, arrears cannot extend beyond the prescribed limitation period. यहाँ लिमिटेशन का एक प्रावधान लगा दिया जा रहा था. जो AFTs दे रहे थे, कुछ ग्रांट कर रहे थे, बट 3 years का लिमिटेशन दे रहे थे फ्रॉम द डेट ऑफ फाइलिंग. In support, the union relied on a series of judgments. Now, what union said in a case including Madhav Lakshman Vaikunte, Anand Swarup Singh, PL Shah, MR Gupta, Shivdas, Union of India, KJS Buttar, Asar Abraham Amin versus LIC, they said there has to be a limitation. Now, arguments by the ex-servants, it was a bench petition. There was a 14 cases was decided in one go in this Union of India versus Girish Kumar. What the respondent said, the right to claim arrears crystallized only on 10 December 2014 with the decision in Ramavatar, which is a justice in rem Now what this justice in rem means, it is a well settled principle. It is like this will be applied to the similarly placed cases. So it is well principled, this is well settled in law as per the decision of Ram Avatar, which was pronounced on 10th December 2014. Though we should get it, denial or restriction of areas amount to deprivation of vested and recurring rights, and the issue is no longer res integra. It is not it is well settled in law, and now it is not res integra. Now it is a Latin term which means that it is not, which is not being settled. It is judgment in rem which is settled, and the similarly placed people will be judged according to the principle held in Ramavatar versus Union of India, which was decided on 10 December 2014. In support, the servicemen relied upon Union of India versus Davinder Singh, Madan Prasad Sinha, Priya Bahuguna, and Bajendra Singh. Certain provisions were invoked, like the letter issued in 2011, 31st January 2011, Armed Forces Tribunal Act 2007, Limitation Act 1963, Pensions Regulations for the Army 1961, Pensions Regulation for the Army 2008. So, and also the Article 300A of the Constitution of India, which says pension is a property and no deprivation save by authority. Now, what the judgment says, and this is very important, I'll read word by word. The sole issue whether areas of disability pension can be restricted to 3 years prior to the filing of the application was answered in negative. No, it is, there is no limitation when it comes to disability pension. It cannot be restricted to 3 years. Pension was not bounty or a ex gratia payment, but a deferred portion of compensation, a vested and enforceable right, partaking of the character of property, which cannot be withheld, reduced, or extinguished except by authority of law. Disability pension is a recognition of sacrifice and not a largesse. So it is a symbol of sacrifice which you have done towards this motherland, towards your motherland, that disability pension is given to you. And third one is the right to seek broadbanding crystallized only on 10th December 2014 with Ramavatar, a judgment in rem. The union as a model employer ought to have extended the benefit without requiring ex-servicemen to litigate. The union had itself, by continuous policy decisions, letter dated 15th September 2014, 18th April 2016, and 18th October 2018, the last with full financial concurrence, determined that the areas were payable from 1st January 1996 or 1st January 2006. Having done so, it could not resile and confine areas to 3 years. That would acknowledge the right in principle while denying the substance and would violate Article 300A. So it is well settled in law, and there are certain letters, the office memorandums, the office letters, which prove that union is giving. Then why they are not giving the areas to these ex-servicemen? The limitation objection. Broadbanding attained finality on 10 December 2014. The union's own order of 18th April 2016 acknowledged areas flowing from 1st December 1996 without curtailment. The AFT had no application, so section 22(1) subsection C of the AFT had no application, and there was no delay or lashes. So the union's appeal was dismissed. The tribunal orders restricting areas to 3 years were quashed and set aside. The ex-servicemen held entitled to the disability pension, including broadbanding, from 1st January to 1996 or January 2006, as the case may be, with interest of 6% arrears, no order as to cost. This is the well settled principle which was propounded in this case of Sergeant Girish Kumar. एरियर्स का केस था ये, जिसमें लिमिटेशन एक्ट, आर्टिकल 300A ऑफ द कॉन्स्टिट्यूशन एंड ब्रॉडबैंडिंग को क्लियर कर दिया गया. दिस इज द लेटेस्ट जजमेंट ऑफ द सुप्रीम कोर्ट ऑफ इंडिया which was pronounced in 2016, which settled the principled position that the area should not be limited to 3 years. It is a continuous recurring right of the disabled soldiers, and it is not something which you are giving. It is not an ex gratia. It is not a bounty, but uh, a service which you have done to the motherland is given. So this case is very important, which because it settles the areas component of the disability. I hope you liked it. Jai Hind.